Abusia minchia misanso emo akwaba. Ene eyade a deputy attorney general, doctor, justice Somsai, abusia kopie mu e court. Ni na fa ye chema Wontumi. Ne nsam ya ho. We de mema mekasa enye tintin pese ye ko na yeti enkomo ya ba about. Yes. Mama yintie na yenche ya adwena be hia ne so. Se be media agi so ni de kwan so ha yini atem. Nemum ya adwen na ye kire mama yenko na yintie enkomo ba about. Chema Wontumi after say 20th of July okopie mu ewo nsawam no ensemo a efiri akire eba no ebi ne de ahin mama yitie ne aba sesi ana yenche ya adwen ewo ye comment section na ha that's why be media GH yeah that's
lawyer Atta Akyea confirms they say deputy attorney general mom kwan so mom e plea bargain na on be plea bargain na bibia succeed ya on be close case no na chama Wontumi kura de ka se ye kansem ni nyina finchem pa dia be 3000 years kura no my just say a ganze prerogative of mercy and answer presidential pardon never born into no lawyer Atta Akyea with interview confirmation yeah say attorney general mom kwan say for the second time no mom komra no me plea bargain say bibia succeed ya be close case from the horses so map abusia me pa cho yanko ne nkuti Atta Akyea na schedule me like
because you have another case in your hands, Wontumi, Exim Bank.
Yeah.
Share with us. Today, you appeared, asked for time, essentially to go and renegotiate as part of the plea bargaining. Share with us essentially what your prayer to the court was.
In the first instance, you are not kind to say that I'm a lucky man. You've put more work on my shoulders. But essentially, the judge agreed, and Honorable Deputy Attorney General Serves also agreed that you attempt a plea bargain and then come back to the court and announce it. So we'll take up that initiative and see whether we can broker a deal, and that matter will come to an end. So that is what happened. But relating to the Adubuahin case, Cromwell, who is the last witness and investigator for the Attorney General, is still in the box. And today he made several concessions. That he didn't understand the national security space. And I begin to wonder, I don't have to say so many times, that how can you investigate the national security when their matters are clandestine, when they do undercover operations, when they have even operatives functioning in banks? How can you come to terms with a space that you don't understand? And why should we use your ignorance to send somebody to jail? So this is where we are. Tomorrow is a good day for the judiciary, so we won't come. But Wednesday we'll continue with them and see how.
Case in your hands, Wontumi, Exim Bank.
Yeah.
Share with us. Today, you appeared, asked for time, essentially to go and renegotiate as part of the plea bargaining. Share with us essentially what your prayer to the court was.
In the first instance, you are not kind to say that I'm a lucky man. You've put more work on my shoulders. But essentially, the judge agreed, and Honorable Deputy Attorney General Serves also agreed that you attempt a plea bargain and then come back to the court and announce it. So we'll take up that initiative and see whether we can broker a deal, and that matter will come to an end. So that is what happened. But related again, the Attorney General cannot force a plea bargaining arrangement on the, accused person. So I think at least you should give the accused person and his lawyers the wisdom to make that election. It's not for the Attorney General to say, at all costs and by all means, you should come for a plea bargain relative to all the cases. That's the point of the matter.
So you think the Exim Bank case, doing plea bargain on the Exim Bank case is the best, for you and the whole team?
It's a good strategic option that we want to exercise.
Thank you, sir. What do you have to say about that?
Well, it is the right of the accused person to plea bargain or not to plea bargain. The Attorney General cannot force a plea bargaining arrangement on the, accused person. So I think at least you should give the accused person and his lawyers the wisdom to make that election. It's not for the Attorney General to say, at all costs and by all means, you should come for a plea bargain relative to all the cases. That's the point of the matter.
So you think the Exim Bank case, doing plea bargain on the Exim Bank case is the best, for you and the whole team?
It's a good strategic option that we want to exercise.
Thank you, sir. What do you have to say about that?
Well, it is the right of...
But
I know that there's light at the end of the tunnel.
Is it that it's your challenge with what appears to be, from your submission, a case of selective justice, or you still think that based on everything that you've heard and everything you've read from the documents, you still think that Wontumi?
I'm surprised you're even.
Wontumi did no wrong.
No, I'm surprised you're even asking me whether it's a case of selective justice.
Right.
Is it not clear to everybody? The president himself is saying that his people are involved in Galamsey. Nobody has been prosecuted.
Okay.
The Attorney General himself told us that he has referred key members of the party to Yoko. A year ago, the same time Wontumi's case started. We've not heard anything from them. So it's not about me saying it. It's palpable. It's clear for everybody to see how selective it is.
I get it. My question is your concern the matter of selective justice, or your concern has to do with the basis upon which Wontumi was incarcerated? Which is more important to you? Both.
Yes.
Okay. So you disagree with the reasons that the court gave?
Absolutely. The party has come out clearly with our.
All right.
But of course, we can disagree with the courts.
Yeah, that's not.
If you have the right to disagree with the courts. Yes, and that is why we are going to an appeal.
Okay.
Any appeal is a critique of the previous judgment.
Okay.
And so that point must be made.
All right. Okay, see. I've sought my clarity. Please come in.
Okay. I mean, like colleagues, I suspect that I have a right to describe Wontumi as a friend. I recall that more than 25 years ago, a gentleman called Atta Akyea brought Wontumi to my office. I was then working in the inside.
PNC's Atta Akyea?
Yes,
okay.
He brought Wontumi to my office. Okay. He was going through some problems and so on. And indeed, Wontumi was in my office 2 or 3 times a week over a long period of time. And that was long before he became regional chairman of the New Patriotic Party. And I've met him a few times. The last time was about 3 months ago when I went to eat somewhere and he showed up. And he was very, very confident that he was not going to go to jail. And I won't state the reasons he gave because that may be prejudicial. So I won't state the reasons he gave why he was so confident that he was not going to go to jail. So he's my friend. Okay.
It won't be prejudicial anymore, Uncle Bisi, because the judgment is out now.
Pardon?
The judgment is out
now.
Process. No, it hasn't been appealed yet.
I know what I don't want to say.
Okay, that's fine.
I know what I don't want to say. What he told me.
I take him.
And he told me that in the presence of 3-4 other friends. You understand? Fine. So I wouldn't say that now. Right. I would presume that what he told me was in confidence.
That's true.
And I'll keep the confidence. However, I think that, look, we must approach this case from the position of law. Okay? This case must be approached from the position of law. And the law is that any person against whom charges are brought against should be given every opportunity to defend themselves. They have a right to remain silent. They have a right to engage lawyers of their choice and so on. Nobody has made that case that he was not given an opportunity to defend himself. Nobody has raised that issue. He chose his own lawyers. He had a right to remain silent and so on. All of those were observed. Now, the position of the law is also that if you're convicted by a competent court and you have reservations about the judgment or you think that the judgment was not proper and so on, there are processes of appeal. So you can go to the Court of Appeal, for the decision and argue that the decision should be reversed. And to that extent, there's absolutely nothing wrong with the decision of his lawyers and party lawyers who want to go to the Court of Appeal. That is the position of the law. There's nothing wrong with that. Now, even if the Court of Appeal should make a ruling or should make a determination which they still find unacceptable, they can still then move on to the Supreme Court. And even when the Supreme Court has made a decision, they can go for a review.
Yeah.
This is the position of the law.
Right.
So I cannot, in fairness, be arguing about the decision or the intention to go to the Court of Appeal. That is proper, that is right. It is the right of Wontumi to go to the Court of Appeal, and nobody can contest that. My problem is this, and my brother Collins had said so, that the case is a political case because he happens to be chairman of the New Patriotic Party in the Ashanti region. That's problematic. You understand? That is to suggest that a chairman of a party in the party stronghold cannot commit a crime. And that if he commits a crime and is tried, it becomes a political case. That's a huge problem.
Well, not necessarily. Okay.
Explain to me.
If you say that he cannot commit a crime, I don't think that's what he suggested. He just meant that it's such a big blow to the party because this is a guy who chairs the party in their stronghold.
It doesn't make the case a political case.
He may have to explain why he thinks it's a political case. He may have to come back and explain that.
The fact of his being chairman of the New Patriotic Party in the Ashanti region, which is the stronghold of the party, does not make the case a political case.
Okay, that's a fair point.
That's the point I'm making. Now, the other ingredient, which my brother and friend, and Collins, I'm entitled to call you a brother and friend, I suppose.
I'm humbled.
Yes, sir.
Yes.
The other point he makes is that, look, who prosecuted him? It's the Attorney General who prosecuted him. The Attorney General is a member of government. In fact, he sits in cabinet. And therefore, this is a political case. That's a huge problem. Okay. Now, we have made reference to these provisions of the Constitution over and over and over again. And I'm going to do so again today. This is the 1992 Constitution.
Okay.
In the 1992 Constitution, Chapter 88, Clause 1 says, there shall be an Attorney General of Ghana who shall be a Minister of State and the principal legal advisor to government. The Attorney General shall discharge such other duties of a legal nature as may be referred or assigned to him by the President or imposed on him by this Constitution or any other law. The Attorney General shall be responsible for the initiation and conduct of all prosecutions of criminal offenses. This is the Constitution. So if you make the argument that the fact that the Attorney General is a member of government, the cases he prosecutes become political cases, there's a huge problem. So by extension of logic, you'll be saying that the prosecution of Atta Akyea was a political case. So any case prosecuted by the Attorney General, by extension of logic, becomes a political case, in which case there can be no prosecutions in Ghana. That's a huge problem. Okay. Now, the other thing that I like to touch on is that we are always, anxious, and maybe legitimately so, to defend the rights and reputations of persons who are prosecuted or who, the judiciary has to make decisions on and so on. That's fair. I'm not worried about that. But in the process, we deliberately attack the integrity and reputation of persons who sit on the bench without justification. Because to say that this case was not judged on its merit and that it was a political case and that Chairman Wontumi is a political prisoner is to attack the integrity of the judge without foundation, without basis. There's a saying that the High Court judge did not consider law, that the High Court judge was influenced politically in order to come to this conclusion. This is most unfair.
Have you heard about the ethnic considerations too? I don't want to repeat what the person put out on social media, and it became very topical.
I don't think we should even
Yes,
raise
yes,
that.
I get
It's
it.
so nauseating.
Yeah.
It's sickening. You understand?
Yeah.
So nauseating and sickening. Horrible. Should not be permitted.
Yeah.
And especially when that is done by political leaders.
Yeah.
You understand? And come to think of it, this lady who sat on this case, from what I've learned so far, was appointed by the previous government. You understand? And I think that it would have been wrong if, for example, she had set Wontumi free and said that the case had no merit. To go to the root of who appointed her, to make a determination as to whether the case was political or not.
Yeah.
Let's be fair to our judges. They're so unfair. For our own narrow political interest, we will destroy anybody's reputation. The same way you want to defend the rights of Wontumi, the same concerns, the same principles should guide you in the defense of the rights and reputation of those who sit on the bench. That's just being fair.
Absolutely.
It's just being fair. You cannot roast people who are on the bench just because they happen to carry out their professional duty and you don't like their style or you don't like their conclusions. That's most unfair to the bench. You understand? And I'm not happy with the way in which things are moving. Yes, there may be legal points, legal basis for appeal. Emphasize the legal basis for appeal. Go to the Court of Appeal and get a judgment and stop destroying a judge who, for all intents and purposes, may be innocent. You understand? We are not bound to agree with decisions of all the judges. Indeed, we have a right to criticize decisions of judges and so on. But to recklessly and without foundation seek to destroy their reputation and so on, it's unacceptable. Clearly unacceptable. And I insist on that. Now, one of the issues which has been raised, and this is a purely legal issue, and I discussed this person in all honesty as a layman. Okay? I'm not a lawyer, but it's an issue which has been raised. And I'm entitled as a layman to discuss these matters because these are matters which affect all of us and so on. The point has been made that accused persons are not under obligation to, as it were, even speak during their trials. They can remain silent. They can refuse to answer questions and so on. Okay. So the proof of the offense must be established by the prosecution. The accused person has no obligation to prove his innocence.
That burden is not on them.
The burden is not on the accused person.
Yeah.
Okay. Now, in this judgment, which I've read very carefully, and this morning I was asking for a copy, which you haven't given me, so I could do the
We'll do that.
properly.
It's on his way, sorry.
But Moro,
Yes, sir.
part of the judgment
Yes.
says that certain things were alleged against Wontumi,
Right.
and that in cross-examination, Wontumi did not respond to that.
Yes.
They were not challenged. And therefore, the court assumes that they are true.
Right.
That's a problem. That's a proper problem with the judgment. Okay? Because by extension, the argument the court is making is that because he did not challenge those assertions,
Yes.
especially during cross-examination, they must be held as valid.
Yes.
That imposes the burden on the accused person rather than on the prosecution.
Yes.
And I find this problematic. But this is a matter which will be pronounced on by the Court of Appeal, and maybe eventually even by the Supreme Court.
Right.
And there's a matter that dependent on what the Supreme Court and so on come to, may inure to the benefit of Chairman Wontumi.
Right.
So, now, the other argument I've heard, and it's a very interesting argument, is that, Chairman Wontumi was not involved in Galamsey.
Yes.
That's the argument which has been made.
Yes.
He was not charged for directly being involved in Galamsey.
True.
That was not the charge. The charge was that he had been given a concession and that he illegally, without appropriate authority, allowed another
third party
to mine in the concession.
Yes.
So the fact that he personally was not involved is neither here nor there. You understand?
But obviously, before you go ahead to talk about whether it's neither here nor there, but you should also understand those who are seeking to set the record straight on that, because a certain impression is being made that Chairman Wontumi himself was on the field doing Galamsey. You know how sometimes we like to spin things, and that's why those who are correcting that are doing that. But yes, it's a fair point you've also made. You know, there was a certain narrative some people were trying to spin and to make it look as if he himself, as saying Chairman Wontumi, was on the field mining and doing Galamsey, and that's why Collins had to set the record straight on that.
The court didn't say that.
Yes, I know.
The court is clear. The court didn't say that.
I know.
And that was not the charge which had been brought against him.
It was actually a response to spinning doctors, those who were spinning it and making it look like not what is here.
Are we going to
Yes.
base our decisions on social media things and so on? Obviously, that's not where we want to go.
Right.
When you are discussing such an important matter.
Right.
But you see, the judge herself averted